Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's video. On this week's video, we're in session number 2 of our new series entitled The QME's Report, the Compliance, Credibility, and Persuasiveness Checksheet. And I have a fascinating program for you today, which is chock full of ideas, which will dramatically improve the content and quality of your very next report if I can just get you to implement some of the suggestions from today's discussion. And before we get into today's discussion, let's just briefly review some of the topics that we discussed in session number 1 and remind ourselves that the entire philosophy of this program has to do with a new and increased scrutiny and new and increased monitoring of qualified medical evaluators' reports by both the Division of Workers' Compensation and the workers' compensation judges who actually use the reports, or I should say who actually try to use the reports, to resolve disputed issues in the workers' compensation system. And the philosophy of increasing the scrutiny and monitoring of QME reports has to do with bringing qualified medical evaluators' reports up to what are referred to as minimum standards. So the Division of Workers' Compensation, in collaboration with workers' compensation judges, are going to be collectively increasing their monitoring to confirm that QME reports meet the minimum internal construction standards that are described by CCR 10606, and we're going to talk much more about that today. And then also that within the body of the qualified medical evaluator's reports, that the qualified medical evaluator and his or her opinions and conclusions be able to successfully resolve disputed issues in each and every particular case, whatever those disputed issues may be. And the capacity or capability of the qualified medical evaluator to resolve disputed issues rests on the ability of the qualified medical evaluator to qualify his or her opinions as substantial medical evidence. So it's CCR 9793 that requires that the qualified medical evaluator be able to resolve disputed issues. If the qualified medical evaluator is not able to qualify his or her opinions as substantial medical evidence, then those opinions will fail to be able to successfully resolve disputed issues, and the qualified medical evaluation report will be classified as a low-quality report below minimum standards. So in session number 1, we talked about some of those minimum standards, and we talked about how the purpose of this program is not to allow you to, not to show you how to attain minimal standards with your QME report, but rather how to maximize your report, how to maximize the compliance of your report, how to maximize the credibility of your report, how to maximize the persuasive power of your report so that the reader of your report, first of all, gets a wow experience, and then number 2, that your report can actually be used to resolve disputed issues, and it can serve as an instrument to allow quick and successful expeditious resolution of cases that otherwise get clogged up and stagnated within the workers' compensation system. So I gave you several initial suggestions on how to increase the credibility of your report so that the reader of the report becomes impressed by your meticulous attention to detail. And then number 2, I gave you some suggestions as to how to incorporate some powerful language and powerful formatting of your report so that the report has strong visual appeal and therefore strong persuasion power over the reader of the report. And in later sessions of this report, we're going to explore the credibility and persuasiveness of your report in great detail. For today's discussion, I want to talk to you today more about the required elements, the minimum required elements under CCR 10606, and compare and contrast those minimum standards with other minimum standards that are described in other references that we use in the work that we do, references such as the 2016 Physician's Guide and references such as the AMA Guides 5th edition. So both the 2016 Physician's Guide and the AMA Guides 5th edition have their words to say about how we should format our reports. And so using these three references, CCR 10606, the 2016 Physician's Guide, and the AMA Guides 5th edition, we can create a hybrid report format that captures the best of the best elements that are described in each of these reference sources, and that eliminates unnecessary and irrelevant report elements described in some of these reference sources. So elements that have become antiquated, elements that do not pertain to California workers' compensation, etc. And we can come up with a hybrid format using all three of these reference sources to come up with the perfect QME report format layout that hits all the credibility high notes, that hits all the compliance high notes, and that delivers the qualified medical evaluator's opinions and conclusions with credibility and persuasive power. So I want to share with you the very latest ideas in formatting your report so that your reports are among the very best reports that come across the desk of report reviewers at both the Division of Workers' Compensation and down at the Workers' Compensation Appeals Board. So let's begin today's discussion regarding the required elements within the Qualified Medical Evaluation report.
Okay, now in discussing the elements of the medical legal report, there's a couple of references that we're going to draw from. And I'll explain why we refer to several different references rather than one single solitary reference. So we're going to be consulting with the 2001 Physician's Guide. We're going to talk about the AMA Guides 5th edition and what they say should be contained in a permanent impairment report. And then we'll talk about CCR 10606, the physician's report as evidence. And it's kind of interesting because we find ourselves at this date, we find ourselves sort of in between systems. Now, we've been using the AMA Guides 5th edition since 1/1/2005 as our Bible for how to rate permanent impairments. And that's the qualified medical evaluator's job, is to rate the presence or absence of permanent impairments. Well, the rating of permanent impairments is but a small factor in the overall qualified medical evaluation report. And for instruction on how to write the qualified medical evaluation report, we rely on the 2001 Physician's Guide. And the 2001 Physician's Guide is an updated version of earlier years' editions of the Physician's Guide. Now, for those of you that are new to the system and new to qualified medical evaluations, long before we had the AMA Guides, we relied upon the 1997 Permanent Disability Rating Schedule for rating permanent disabilities. Now, we no longer rate permanent disabilities as qualified medical evaluators. We rate permanent impairments, as those impairments are described in the in the AMA Guides 5th edition. But long before the AMA Guides, we've been doing qualified medical evaluations and relying upon the current version of the Physician's Guide as our Bible, as to provide instruction for us and direction to us as to how to produce qualified medical evaluation reports and how to do our qualified medical evaluation examinations. So the principles that are contained in the 2001 Physician's Guide are still relevant and are still operational and are still valuable. And I particularly like the 2001 Physician's Guide because it gives us great philosophy and great background as to our procedures. We simply incorporate the AMA guides for the specific section in our report wherein we perform our physical examinations and wherein we provide for a permanent impairment rating. So in that sense, we are going to formulate and format our medical legal report around the dictates as described in the 2001 Physician's Guide, with a few subtle additions and updates and upgrades that are required by the AMA guides. And then finally, we're going to put this whole package together in such a way that it complies with the requirements of CCR 10606, which talks about what are the elements that are required for a physician's report to qualify as evidence within the workers' compensation system. Okay, so let's begin first with a discussion here about the 2001 Physician's Guide. So I don't know how many of you have the 2001 Physician's Guide. If you do not have it, I recommend that you do get it. It's still available, and it's available in a downloadable PDF file from the Division of Workers' Compensation Medical Unit's website. And that's where I retrieved my electronic file. So once you have it in electronic format, you can print it out if you want, or you can simply keep it on your computer in electronic format and use it that way. It's quite convenient to have it in electronic format because you can do anything you want with it. You can put it on your tablet, you can put it on your smartphone, you can put it on your desktop in your computer, and I myself, I have it in all of those locations because I do refer to the 2001 Physician's Guide quite frequently. As I said, it's a great reference and it contains great historic philosophy regarding the work that we do. Okay, so let's talk about the 2001 Physician's Guide. In the 2001 Physician's Guide, they give us what they refer to as their guidelines for a well-written report. And by well-written report, we are referring to a report that's rateable. That's rateable by the raters at the Disability Evaluation Unit. What good is a report if it's not rateable? Okay, it should be rateable the first time through. In other words, the parties should not have to request a supplemental report that costs them additional money to have you clarify some discrepancy or some inaccuracy or some omission in your report that renders your report not rateable. So we're going to talk about what are the elements that should be contained within your report in order to contribute to the things that we talked about earlier, the credibility, the accuracy, and the persuasive power of your report, as well as rendering your report rateable down at the Disability Evaluation Unit. Okay? So your report should contain should contain all of the following major topic headings. Okay, these are major topic headings that should be contained within your report. So number one is the identifying information, and we'll talk about what type of information should go in each of these sections here in a couple of minutes, but let's just elaborate on the major topic headings at this point. So identifying information. Number two is an opening statement wherein you give the parties, where you set the stage for the parties. Number three is the sources of information. Number four is the history of present illness or injury. Number 5 is the present complaints, or what are the current symptoms that are related to the industrial injury. Number 6 is a history section, and the history section should be a thorough section in your report that contains at least 3 subsections. Number 1 is the social history. Number 2 is the review of systems. And number 3 is the relevant medical history, or relevant medical information. And it's interesting with regards to relevant medical information. Relevant medical information is an important section in your report, if for no other reason that it justifies the use of the ML 104 complexity factors for your billing under the code ML 104. One of the requirements of the ML 104 level of billing is that you produced an examination and an evaluation that involved prior multiple injuries to the same body parts as the current body part that you're evaluating for the current industrial injury. So it's under the relevant medical history section of your report that you would justify and expand upon the use of that particular complexity factor. Number 7 is your physical examination section. Number 8 is your diagnosis. Number 9 is the causation of the disability. Number 10 is the permanent and stationary opinion that you're going to provide. Number 11 are the factors of disability, at least as those are described in the 2001 Physician's Guide. And as I said, we no longer provide for permanent disability. We now provide for permanent impairment. And I say that with the caveat that at least for injuries after 1105, we provide for permanent impairment. And in certain cases where the date of injury is prior to 1105, we will be providing for factors of disability as related to the 1997 permanent disability rating schedule. But at this date, those instances are becoming rarer and rarer, and more of our work involves opinions on permanent impairment. Okay? Number 12 is our opinion on apportionment. Section 13 is where you discuss the medical treatment that the injured worker has received to date. In Section 14, you talk about either further medical treatment or the need for future medical treatment. And then with Sections 15 and 16, we conclude the report. And in Section 15, you provide your reasons for opinion. And let me just say a couple of comments about reasons for opinion. The reasons for your opinions and your conclusions has become increasingly important and introduces a new topic which we'll simply entitle, quote, substantial medical evidence, unquote. And I'll talk more about substantial medical evidence in just a little bit in this program, but substantial medical evidence is the new standard that our opinions and conclusions must rise to and adhere to in order to qualify as opinions and conclusions that the parties can use. And in order for opinions, very briefly here, in order for opinions to qualify as substantial medical evidence, the opinion and or conclusion has to be supported with the reasons for the opinion or conclusion. And this is referred to in the industry as the how and the why. How and why. You must explain how and why you arrived at your opinion or conclusion. And we'll talk more about that, but there's a specific section in our reports that will qualify our report as substantial medical evidence. And then finally, you conclude your report with the mandatory disclosures and declarations with your signature, your disclosure of significant financial interest, and then also the date that your report is mailed to the parties, and also an indication as to what county the report was mailed from. Okay, so those are the report elements, required report elements as required by the 2001's Physician's Guide. And we'll get into a couple of comments about the AMA guides in just a minute. And then what we're going to do is we're going to take the requirements of both systems, both the 2001 Physician's Guide and then also the AMA Guides 5th edition, and we're going to come up with sort of what I refer to as a hybrid report format that encompasses and includes all of the required elements, that is, all of the elements required by both the 2001 Physician's Guide and all of the elements required by the 2005 AMA Guides 5th edition, which will provide us with a report that contains every possible report element required to resolve contested issues in the workers' compensation system, and does not contain superfluous, extraneous, and duplicative report sections. So what I'm going to provide for you is an exact report format that you can use to fashion your own reports after. That'll be coming up in just a couple moments. The disclosures and mandatory declarations are on page 110 of the Physician's Guide. You must disclose whether or not any other individuals were involved in the production of the report. And we saw that very briefly when we talked about CCR 41 and the ethical requirements. And that is that the opinions and conclusions of the report have to be drafted solely by you as the qualified medical evaluator. Now, other parties can participate in the preparation of the report, and if that is the case, you need to disclose the name, the qualifications, and the role that that party played in the participation or in the production of the report. So write your reports yourself. If other parties are involved in the production of the report, you need to disclose that fact. And then finally, we include the mandatory declaration of no specified financial conflicts of interest. And these are all included in the 2001's Physician's Guide. Okay, so let's go back now to the 2001 Physician's Guide, and let's go to the section in Chapter 6 described as the required elements on page 103. So let's scroll down there to page 103. Okay, and this is, well, actually, this begins on page 99. Okay, so we're here in the section of the 2001 Physician's Guide talking about writing the medical legal report, and we're going to talk about the required elements that are described in this text. So we're on to the required elements. Okay, so the AMA, this is the 2001 Physician's Guide. They talk about including identifying information. They talk about an opening statement. And let's just go over a couple of these to describe some of these elements that may not be described in the AMA guides. So with identifying information, it says that the heading of the report should provide the information necessary to identify the report, including the date of the report, the name of the applicant, the date of injury, the claim number, the Workers' Compensation Appeals Board number when possible, and any other information necessary for clarity to the parties. So, for example, the name and address of the claims administrator, the name and address of the applicant attorney, the name and address of the defense attorney, perhaps a picture of the examinee to identify the examinee as an actual person. All of that is included in the identifying information. I'm going to show you examples of how this would look in your QME report here in just a couple moments. Your report should include an opening statement. This section should provide information on the context of the report and the performance of the examination. In this section, you're required to provide the date, the place, and the duration of the exam. You're required to describe the actual time spent face-to-face by the physician with the injured worker. Face-to-face time includes the time in which the evaluator takes the history, performs a physical examination, or discusses the worker's medical condition with the worker. Face-to-face time does not include time spent in the performance of diagnostic or laboratory tests, such as blood tests or x-rays, or time spent on records review or report writing. And I'll show you how to construct an opening statement that complies with all of these requirements, including describing the face-to-face time and in describing the time spent on review of records. Okay, the report should contain a section that describes the sources of information. This section should contain a list of all the medical records that were reviewed in the preparation of the report. You must also record any non-medical information and its source that was received from either party and reviewed in preparing your report or in formulating your opinion. You should list the names of anyone other than the patient who was interviewed or with whom the case was discussed. And nowadays we refer to this as our review of records section. And it's interesting because the review of records section in our report actually is governed by several labor codes and several codes of regulation. And I'll show you how to construct the review of records section of your report so that it complies with all of those requirements and also complies with the requirements as described here in the 2001 Physician's Guide. The report must have a section describe the history of the present injury or illness. And this is the injury or illness that is the subject of the workers' compensation claim. So let's just read some of these requirements. The report must include a comprehensive and factual account of the industrial exposure, the applicant's complaints, and the treatment the applicant has received. And I talked earlier in the program about an efficient and effective way to do this. The nature of the claim will determine how extensive this history must be. Injuries resulting from cumulative trauma or occupational illnesses will require a detailed explanation of the applicant's job duties, the conditions of the injurious exposures, including the approximate time spent on the tasks in question, and the temporal relationship between the exposure and the symptoms. The history for a specific injury should describe the activity that immediately preceded the accident and how the accident occurred. And we refer to this, and let's create a footnote right here. We refer to this is what's called the mechanism of injury. Mechanism of injury. And you should spend extensive time in determining the mechanism of the injury, because it's the mechanism of injury that you're going to rely on later on in your report when it comes time to provide opinions and conclusions, especially on the causation and apportionment of the permanent impairment. So mental note here that extra emphasis is placed upon the activity that immediately preceded the accident and how the accident occurred. We refer to that as the mechanism of injury. So they elaborate on that here in the 2001 Physician's Guide. They say that whenever possible, you should provide relevant details such as the approximate weights of objects, the worker's position while performing the task, the height of a fall, and all specific and detailed information that fully elaborates on the mechanism of injury. Your report should describe what happened after the injury. Were they transported by ambulance to a hospital? Did they continue working? In other words, in the history section, you describe the history of the injury, the history of the medical treatment, the history of the symptoms from onset, meaning from the date of the injury, all the way up to present time, immediately preceding the date of your evaluation. Finally, if there is more than one injury, the report should clearly describe each injury and the subsequent treatment or changes in treatment if treatment was ongoing at the time of the second injury. Your report must list a section that details the present complaints. Or we might title this, instead of present complaints, we might title this present symptoms. Present symptoms, I think, is a more neutral and politically correct term. So in this section, you should explain the patient's current symptoms. You should attempt to relate the frequency, duration, and intensity of the complaints to specific activities and note temporal patterns, such as stiffness in the morning or pain that increases throughout the day. Pain that interferes with activity is a rateable disability in workers' compensation, so it's important that the report give a clear understanding of the extent of any limitations. Now, this is specifically referring to injuries prior to 1/1/2005, when we had different descriptions for pain than what we use with the AMA guides. Now, this statement is somewhat correct in referring to the 2005 AMA Guides 5th edition, because pain we can provide for permanent impairment due to the added burden of pain in Chapter 18 of the AMA Guides. So, regardless of the date of injury, it's important that we provide very specific and clear descriptions of the pain, because regardless of the date of injury, it's possible that the examinee could qualify for either permanent disability and or additional permanent impairment due to any pain that they may be experiencing. Okay, so that's the history section. I'm sorry, that's the present complaints section. Then in a separate section, entitled History, this section should summarize important medical events or conditions that may have bearing on the applicant's injury. We might refer to this as the relevant medical history in order to distinguish it from the history of the present injury or illness. So in this section, we would have also a social history, we would have a review of systems, and any other relevant medical information. This is where you would question the applicant about any pre-existing injuries or conditions in the affected part of the body that is the subject of the workers' compensation claim. And earlier in the program, I gave you some suggestions as to how to elicit the relevant medical history. Okay, next section is the physical examination and the findings of the physical examination. Now, of course, this is the main body of the QME report, and this is the section of the QME report over which we as doctors have absolute domain. The physical examination section of our report is the section where we shine as the medical evaluator. So it's my opinion, and I stated this earlier in the program, that your physical examination section of your report should be a masterpiece. It should be clear. It should be precise. It should show exact measurements that are formatted in charts and tables and with bullet points. And it should be clear to non-medical readers. Now, for dates of injury prior to 1/105, we used a different Bible for our guidance on the physical examination. We used the Evaluation of Industrial Disability by Packard-Thurber. We no longer use that. We now use the AMA Guides 5th edition. And they specifically stated prior to 1/105 that you should not use the AMA Guides because the AMA Guides outlines different measurement techniques than those used in California, although California has now adopted the measurement techniques described in the AMA Guides. But if you're evaluating dates of injury prior to 1/105 and you're required to use the 1997 Permanent Disability Rating Schedule rather than the AMA Guides, you will need to be familiar with the measuring guidelines described in Packard-Thurber. Describe the purpose of clinical tests rather than referring to the test only by name. So don't list the findings of tests by, for example, Kemp's test was positive. You would not say that. You would not say that Milgram's test was negative. You would describe the purpose of the test. For example, Kemp's test is a test that has as its purpose to load and test the intervertebral facets, joints of the spine. So, for example, you might say facet compression test. Facet compression test was negative. Or sciatic nerve stretch test was negative, rather than using the term Lassaig's test. And so, in other words, describe the purpose of clinical tests rather than referring to the tests by name. Now, it says that in this section, if you have performed or reviewed any diagnostic tests, such as X-rays or EMG, you should summarize the findings in this section. We're going to see that when we create our hybrid format of QME report, we're going to have a separate section specifically for diagnostic tests, because I'm sure you'll agree with me that most times by the time the examinee gets to the qualified medical evaluation, they've had many types and even repeat diagnostic testing, including X-rays, MRIs, CT scans, electrodiagnostic studies, perhaps ultrasounds, and all these different types of studies, arthrograms and myelograms. And so the diagnostic studies we're going to separate out and isolate in their own specific section to make it easy for the reader to locate and to summarize the results of all the diagnostic studies. Next, we include a section entitled the diagnosis, and this is where you give a specific diagnosis for each and every condition you are evaluating. And with regards to the AMA Guides 5th edition, I'll give you some suggestions as to how to fashion your diagnosis so that your diagnosis aligns and coincides with your description of the permanent impairment. You should have a section that describes the cause of the disability. We might refer to this in our report as the causation section. So let's call this causation section of the report. Okay. This section addresses the relationship between the conditions you found on examination and the injury or occupational exposure. In some situations, this section can be quite brief. More detailed discussions is required in cumulative trauma cases, occupational illnesses, stress claims, or in cases where additional body parts or systems have become affected since the original injury, and this happens all the time in the current climate of the QME evaluation. We're seeing the addition of psychologic injury and we're seeing the addition of additional body parts or systems in addition to the principal injuries. So the causation section, at least in the current environment, is a section that has the potential to become quite lengthy and quite complex. And for that reason, the causation of the disability or the causation of the permanent impairment qualifies as one of the complexity factors under CCR 9795 and allows for a higher level of complexity of the report and a higher level of billing for the report when the report qualifies as a complex report. So it's my opinion that the causation section of your report is something that you should be very familiar with. Be very familiar with working in this section. You should be very familiar with describing the causation of the disability, and this is a section of your report that you're going to want to be a masterpiece. You're going to want it to be very thorough and very accurate, and you're going to want your opinions on causation of the disability to qualify as substantial medical evidence. Okay, so this important section of the report should include an opinion on or a section on the permanent and stationary status. And it's interesting, it says that in this section you should state whether or not you have determined the patient's condition to be permanent and stationary, along with the reasons for this determination. Isn't that interesting that we have inferences and implications? I guess this would be an implication as to substantial medical evidence all the way back here in the 2001 Physician's Guide. And isn't that exactly what they're asking? They're asking us to explain the how and the why we feel that the examinee may have reached a permanent and stationary condition, or if the examinee has not reached a permanent and stationary condition, explain the reasons why. Why are they not permanent and stationary? And explain your reasons in a clear and well-formatted fashion. And I suggest the use of listed bullet points so that the reader of your report can clearly see each of the reasons as to why you arrived at your conclusion. The report should contain a section entitled The Factors of Disability, wherein you describe the subjective factors, the objective factors, the work restrictions, and the estimate of loss of pre-injury capacity. This, of course, relates to injuries before 1105. And in our current reports related to the AMA guides, we're going to title this section Permanent Impairment. Okay, and I'll talk a little bit more about that in just a couple minutes when we get into the AMA guides. Your report should contain a section on the apportionment of the disability, and we're going to sort of hybridize this as well to coincide also with our causation section for injuries after 1105. But it's important to remind ourselves that apportionment of the disability describes the degree to which any permanent disability is due to pre-existing conditions or underlying disease. Apportionment applies only to permanent disability. Apportionment does not apply to medical treatment. It does not apply to any of the other benefits associated with workers' compensation. It only applies to the benefits related to permanent disability. And we'll talk more about some current ideas related to the apportionment of permanent impairment to causation when we get in our discussion of the AMA guides. Okay, and then just a couple of more sections. We should have a section of our report entitled the medical treatment that's now needed to cure or relieve the effects of the industrial injury. That is when you feel that the examinee is not at permanent and stationary condition or has not yet reached maximum medical improvement. If the examinee is at a permanent and stationary condition, and you provide for a permanent impairment or permanent disability factors, or a permanent impairment rating, I should say, there needs to be a section in your report entitled the future medical care or future medical treatment. This is where you elaborate what type of treatment could be necessary to cure or relieve the effects of the industrial injury, or to cure or relieve any flare-ups or exacerbations as they may arise. And then finally, after all of that is done, there's still some work that needs to be done. You need to have a section in your report wherein you describe the reasons for your opinion. And here it's so fascinating. It says that for each opinion, you must provide a clear description of why you have reached that opinion. You should also provide explanations for any unusual findings. This should be done throughout the report in the appropriate sections. And isn't that fascinating? And I've reiterated this time and time again. Now, it's interesting because the Escobedo case described substantial medical evidence as relating to specifically our opinions on permanent impairment and our opinions on the causation and apportionment of the permanent impairment. But here in the 2001 Physician's Guide, it says that this should be done throughout the report in the appropriate sections. So what that means is that for every opinion and conclusion that you offer, you need to have support for that opinion and conclusion. And you could simply state in sentence format, my reasons for this conclusion include colon, new line, numeral 1, state your reason. Numeral 2, state your reason. Numeral 3, state your reason. And have as many numerals and as many reasons as you have and as it takes to properly substantiate your opinion or conclusion. And doctors, opinions and conclusions without the reasoning behind the opinions and conclusions are worthless. They're meaningless. They cannot be used. It's what's described as conclusory opinions. So you should check and double check your report thoroughly for any unexplained or any unreasoned conclusory opinions. It was described all the way back in the 2001 Physician's Guide, long before we even had the Escobedo case. And it says here, isn't this amazing? A medical legal report that does not contain the reasoning behind the medical opinions reached is worthless in the workers' compensation system. Isn't that amazing? I bet if there was a footnote here, which there's not, but I bet we could go to the footnotes or the bibliography of this book, and this would probably reference the Zemke case, which we stated came about, I think it was in the 1970s. Well, this guide was written in 2001, so probably this is a derivative directly from the Zemke case. Okay, so after we have the reasons for our opinion, we then include disclosure of other individuals involved. There's a mandatory declaration. There's our signature, and there's our disclosure of any significant financial beneficial interest. And I want to go over these sections here in some detail because these are still required with our current QME reports. And these are sections that are not described and in no way have anything to do with the AMA guide. So I want to review these disclosures with you, and then we'll go up to our QME report template, and I'll show you how each of these components is formatted and how it's laid out in an actual QME report. So one of the disclosures is that you must disclose the name, the qualifications, and the roles of other individuals who participated in the evaluation by performing such tasks as taking and outlining the medical history, such as reviewing and summarizing medical records. And doctors, this is where many doctors do not comply with this requirement. Many doctors use third parties, they're referred to as historians, to review and summarize the medical records, but nowhere in the report do they disclose that these other individuals were involved. So it is required. Anyone who administers diagnostic studies has to be disclosed. Anyone who drafts or edits any part of the report is required to be disclosed. It says that a violation of this provision can result in your suspension or termination as a qualified medical evaluator. Labor Code CCR 4628. All reports must have the following declaration in its entirety in every medical legal report, whether that be the initial QME report, supplemental report, follow-up reports. All must contain the following declaration. I declare under penalty of perjury that the information contained in this report and its attachments, if any, is true and correct to the best of my belief and knowledge, except as the information that I have indicated I received from others. As to that information, I declare under penalty of perjury that the information accurately describes the information provided to me, and except as noted herein, that I believe it to be true. Signature. The report must be signed by the physician who prepared the report under penalty of perjury. If you sign the report, you must have examined the applicant, taken the applicant's history or reviewed with the applicant an outline of the history. You must have reviewed the medical records and composed and drafted the conclusions of the report. Include the date and county where the declaration was signed. Finally, your report must disclose any proprietary interest or co-ownership you have in any laboratory, pharmacy, clinic, or healthcare facility you used in the evaluation. And this most frequently relates to co-ownership in diagnostic testing facilities, such as imaging facilities. QMEs and AMEs are generally prohibited from most self-referrals, with some exceptions. Your report must contain the statement that you have not violated Labor Code Section 139.3 in that you have not made an illegal referral. Violation of this section can result in your suspension or your termination as a QME. Okay, so doctors, that's a lot, and that describes the required elements as they were described in the 2001 Physicians Guide. Let's now go into the AMA guides and see what the AMA guides requires as far as a clear and concise permanent impairment report. And then what we're going to do is we're going to combine the two formats. The format as it's described in the 2001 Physicians Guide and the format as it's described in the AMA guides. We're going to come up with a hybrid format that touches and covers all the bases required, number one, by the AMA guides for permanent impairment evaluations, and then number two, that are required in the California Workers' Compensation System that may not be described in the AMA guides. Okay? So let's talk now a little bit about the AMA guides.